The question of when and where and how the police can conduct a search falls under the general topic of criminal procedure. In this case, the second word is important. The courts usually look at how the police are acting, and the protections courts have supported are primarily procedural. Criminal procedure civil liberties are found in the 4th, 5th, and 6th Amendments, but today we're only going to look at the 4th Amendment, which reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." According to the 4th Amendment, for the police to get a judge to issue a warrant, they must have probable cause, which is more than just a suspicion or an anonymous tip. Although sometimes judges will issue warrants on pretty flimsy probable cause.
What about the vehicle? What about? It's all. Well, I got your cell phone. I got 4 prescription bottles with the ones that still have pills at least in them. One of them I don't.
Experiences that you have had involving the 4th Amendment.
The 4th Amendment comes into play with criminal cases. You can use the 4th Amendment to suppress evidence. Those would be like drunk driving cases where a cop may search a vehicle because they pulled the driver over under suspicion of drunk driving, but then they search the vehicle and find marijuana or an illegal gun or something like that, and whether that is a warrantless search or whether it's a valid search, whether that evidence should be suppressed or not.
What are some pros and cons to this amendment?
Well, the pros of the 4th Amendment are that, I mean, it's pretty simple. It protects the privacy of citizens, meaning cops can't just bust into your house without having a reason. It ensures that we as citizens, our property is secure from seizure. The government can't just take our property without having a reason for it. And also it ensures that citizens are safe from unfair or unwarranted arrest.
What is the biggest case you have ever worked on?
One that I can recall that involved the 4th Amendment was a drug possession case where our client was actually pulled over. Well, his vehicle was stopped in a park in Carmel. It was late at night, like 8, 9 o'clock at night. A cop pulled up, requested that he step out of the vehicle. He stepped out of the vehicle. The cop asked if he could search the vehicle. He said no. The cop went ahead, arrested him without any probable cause, searched his vehicle, found marijuana, and arrested him and charged him with the possession. The attorney I was working for was able to get that evidence suppressed. The charges were dismissed because the cop did not have probable cause under the 4th Amendment to conduct that search of his vehicle, so the evidence wasn't permitted. So that's the one case I can recall where the 4th Amendment was utilized.
Y'all don't have anything in the car you're not supposed to have, do you? You don't seem sure, sir. There's no marijuana in the car? I'm sorry? I'm not searching, is that what you said? Okay, you don't have any firearms in the vehicle? No dead body? No dead body chopped up in the trunk? Okay. Do me a favor, step out of the vehicle, sir. And if you would, please, ma'am, step out. Stand right here, wait for me, okay? Now leave the window down.
Don't go in my car. Do not go in my car.
I said leave the window down and you didn't. Come over here.
Excuse me?
Come over here.
Okay, we're not.
And give me the keys.
No, I'm not giving.
Get on the ground. Get on the ground. Get on the ground. Get down. Get over there. Stand over there. Stand over there. Get your hand behind your back.
One case of Map v. Ohio. It involves Dalry Map, an Ohio woman who refused to let the police search her house without a warrant. This case, what did it ultimately become about?
What it started out as is not at all what it ended up as. So it started up as a case about obscenity and pornography, and it ended up as a case about whether evidence should be admitted in state trials.
Why is this a landmark decision?
Well, what the decision did was it allowed this rule called the exclusionary rule, which we'll talk about, to be extended to half the states in the union. So it had a sweeping effect on police procedures, that had a sweeping effect on how judges would be hearing cases. And so it really hit a lot of potential cases over the decades to come, and we've seen this now.
Yeah, I think, and just to build on that, another reason why it was a landmark is because it shifted the way we thought about policing. It shifted the professionalism of police forces. It shifted the way we thought about warrants and whether the police could just come into our homes and search for evidence if they thought that we were engaged in criminal activity.
Well, to get us started, we're going to listen to some audio from the oral argument in the Supreme Court.
This Lieutenant White came and showed a piece of paper, and Mrs. Mapp demanded to see the paper and to read it, see what it was, which they refused to do, so she grabbed it out of his hand to look at it, and then a scuffle started, and she put this piece of paper into her bosom. And very readily, the police officer put his hands into her bosom and removed the paper, and thereafter handcuffed her, while the police officers started to search the house. Now the evidence in the case discloses that the state claims there were only 7 police officers, some in uniform. Mr. Green, who was there and was not permitted entrance to the house but was kept outside, says there were approximately 12 police officers in all. Now the evidence discloses that no search warrant existed.
So, what you got in your bag? What I got in the bag? All right.